Necessarily those of this station, its staff, management, or sponsors. Welcome to the Ask the Experts Show with local experts in the fields of legal, health, financial, and home improvement. Enjoy being educated in such topics as personal injury law, community association law, family law, bankruptcy law, along with health show topics like pain management, men's health, and dental implants. Now, sit back and enjoy today's Ask the Experts with host Steve-O.
Hey, hello. I've been going good afternoon, but people think it's a tape show. This is a live show, which means you're going to be able to call in. And God, I'm looking, our lines are going crazy right now. This is without a doubt our most popular show. It's the first Thursday of the month. It's the Kaye Rembaum show on Ask the Experts. And we always have the principal on with us, Robert Kaye. Hi, Robert.
Hello, Ellen. Good afternoon. Good evening.
If you would like to actually watch the show, you can actually go to our Facebook, which is Ask the Experts with Steve O, or you can go to your website, which is kbrlegal.com.
Correct.
How's that? After 4 years, I should know. So, how is everything at Kaye Rembaum?
Well, everything is as well as one could hope under these difficult times. We are working, many of us remotely, some of us are in the office, but covering all the issues that are coming up on a daily basis that our communities are facing and dealing with pandemic type conditions and things of that nature.
Are issues different with the virus? Are you there? I think it looks like he froze up on us. Maybe he'll reboot and come back with us. We're here with Robert Kaye. He's one of the principals with the Kaye Rembaum show law firm. And this is probably one of the most incredible shows. We get so many phone calls. This show, they are a community association law firm, and they're so nice. They come in for an hour once a month and answer your questions. If you have a question, you can call us at 888-565-1470. We are waiting for Robert to come back on. I hope he'll reboot and come back on with us, or maybe he'll be calling. I don't know. So we have so many great shows coming up over the next 6 weeks. Ask the Experts, we bring on leaders in health, legal, financial, and home improvement. And we have some of the greatest shows on, from family law to like the show today, which is the association law, community association law. We have we even have a men's health show. We're waiting for Robert to hopefully come back on with us. And we've got, what we do is we get questions from listeners that write us during the week, and we present those questions to Robert. And if Robert's having problems coming on, the phone number here, Robert, is 888. Oh, okay. We were just told that he's not going to be able to take calls if he has to call in. So maybe I'm going to have to maybe relay the calls to him. This is all new because we're doing video streaming for the first time, and we still have a lot of kinks in this that we're trying to get out. So just be patient with us. We're trying not to have a lot of people here in the studio. I'm the only guinea pig. Uh, okay. We have a caller. Let's go to Jeff.
Hey,
Jeff?
good evening. How are you?
Good. How are you doing?
Doing well, thank you. I actually work with Kaye and Rembaum, and while Robert is
Yeah.
rebooting, if you want, I have some of our events coming up, and I can give you some of the dates.
Oh, that'd be wonderful.
Okay, cool. Well, all of our events are right now are going to be webinars with COVID-19, of course, and anybody can find these events listed on our calendars at kbrlegal.com/seminars. And coming up on May 11th is our first one. It's 2 separate webinars covering emergency orders in both Broward and Palm Beach counties. So the first webinar will be 11:30 to 12:15, covering Broward Order 2008. And the second one will be at 12:30, running till about 1:15, and covers Palm Beach Order number 5. And that'll feature team members, attorneys Michael Bender and Jeffrey Rembaum. And this is along with Campbell Property Management. With me so far, ready for a couple more?
Yeah, let's get some more in.
Okay. On May 12th, we have a 1-hour legal update 2020, and that's from 1 to 2 p.m. That's in conjunction with the Community Associations Institute Southeast Florida chapter. It's a co-run webinar with them, and our own attorney, Lisa McGill, will be running that one. So that's May 12th from 1 to 2. Then on May 14th, we have COVID-19 and your association from 2 to 3:30 p.m. Lisa McGill will be among the panelists there. So that's May 14th. On May the 19th, we have a Florida Legislative Alliance webinar on the review of 2020 approved community association legislation. And that's going to be at 12 noon. And registration information for that will be coming up in the next day or two. We don't have a registration link for that one yet, but again, it can be found on our website, kbrlegal.com/seminars. Then on May 20th, we have an HOA board member certification from 9 to 11:30 a.m. That's also with Lisa McGill and Campbell Property Management. And rounding out the month so far is May 27th, a condominium board member certification from 1 to 3, and Andrew Black will be the presenter.
I'm back.
And again, that could all be found on kbrlegal.com/seminars with their respective registration links.
Thank you, Jeff.
You're most welcome.
Hey, thanks for filling in, Jeff.
Anytime.
Robert's back. Can we go
great.
to our phone calls? Let's go to our phone calls. I don't know who we have first. Oh, we have Eileen first.
Yes,
Eileen?
can you hear me?
I can hear you. Can you hear Robert?
Yes.
Yeah, I think so. I can see him too. Wow, what a handsome
Okay.
fellow.
Gotta have your cousin stop calling.
Are you ready for my question?
Yes.
Go ahead.
If the governor lifts the order today, tomorrow or next week, does that mean that the restrictions that the board put in are no longer valid?
Well, that's an interesting question because this is something brand new for everyone. There is a mix of opinions among the practitioners out there as to whether the decisions that the boards have made is contingent upon the emergency state that the governor had put in place, or if it extends to the county level, the city level, or if the board can make the decision on its own. That's an open question at this point. I think in each situation, the facts and circumstances have to be viewed and determine what's appropriate for that particular community at that time.
Does that answer your question,
I
Eileen?
don't understand. Do we have to call the attorney? You?
I think that's probably the best approach. I can't tell you specifically that you should go back to business as usual because the order expired and didn't get renewed. I don't know that that's going to happen. I don't know that the governor's not going to extend it for a period of time beyond when it's set to expire under its own terms. So it will be interesting to see what happens under those circumstances. I can't imagine them just doing nothing.
I can't. Yeah, I don't want the rest of the residents going berserk and saying that nothing counts anymore.
Well, the residents will do what they do, of course. I think that
Robert,
many
isn't it
people
different down here in South Florida? Isn't it?
It's different
Aren't
in
we
that
going to be behind everybody?
the rolling out of the tight quarantining is slower in South Florida than it is in the rest of the state, although it is anticipated that there will be some additional loosening in the coming weeks. The emergency powers of the board do not evaporate upon the conclusion of the state of emergency. Is that on you or me? That's on my end. So that's the best answer I can give you right now.
Okay, because I thought when I saw the webinar today, I thought that they said that if it once it's lifted, it doesn't extend to the rest of us.
The lifting doesn't?
Yeah, if he lifts the order, I thought maybe we're done.
If the governor lifts the state of emergency, which is unlikely to happen under the present circumstances we face, at some point, there is going to be no more state of emergency. And at that point, while the emergency that exist under the statute may be extended, this is a situation that has not been addressed in the courts. And so it's kind of an open question as to whether or not the board is allowed to keep restrictions in place using their best business judgment, protecting the health, safety, and welfare of the community as a whole, or if they're bound by what the local governments are doing.
Okay, so I'll keep in business. We'll be calling.
That's
Thanks,
the best I can do.
Good. Okay, our next call is Jim. Hi, Jim. Can you hear us okay?
This is, yes, I'm here. Can you hear me?
Yeah, maybe a little bit closer to the phone.
Yes, I'm close.
Okay.
So this is a condo question. So I'm the treasurer of Carrington Condo here in Fort Lauderdale. And we recently had a proxy vote. One of the owners put forward to make the units smoke-free. And so we took a vote. The vote was 4, 12, and 2 against. So what we did is we updated our rules and regulations to show that the inside units are smoke-free. We don't believe that's enforceable because we don't have a committee, a fine committee. And so what we want to do is make it part of our bylaws, I believe, through an amendment to our bylaws. And I just wanted to know if we're on the right track.
Right now, we have it in the rules.
Steps.
So here's the community voted to make your building smoke-free. Is that in the units as well as in the common elements?
No, just inside.
Just inside the units.
Inside the units. That has to be an amendment to your declaration of condominium and presented in the proper format pursuant to the statute and then recorded in the public record.
Okay, and is so make an amendment to our bylaws.
Well, the document that you have to amend is the declaration of condominium.
Okay.
And the declaration will tell you how many owners have to vote in favor of it in order for the amendment to pass.
Yeah, weird.
And then that has to be recorded in the public record of the county where your condominium is located.
But it's basically not enforceable as a rule, correct?
Not enforceable as a rule, correct?
Okay. Okay, that was my question. Thank you so much.
Thanks, Jim.
All right. Thanks for calling.
Let's go to Maria. Are you still there, Maria?
Yes, I'm here.
Okay. You have a question for Robert?
Correct. I have a question. We are a small HOA, like 100 homes, and we have a swimming pool area with bathroom and in there. So the Broward order indicates that we can open the swimming pool, but it doesn't indicate really if the bathroom have to be open. Since we don't have like staff to be cleaning the bathrooms regularly, is it okay to just open the pool and keep the bathrooms closed?
It is okay if there are portions within the facility that you aren't able to properly police and disinfect on a regular basis, then keep those portions and allow for just use of the pool.
Does that answer your
Okay.
question?
So I got another question. I understand
Okay.
like most of the insurances for the board members don't cover any liability for viruses. So is there any like alternative, something to protect the board against or to offer liability or to offer legal advice, like a plan for to protect and for this kind of claims?
Well, when you say it doesn't protect you against viruses, what type of claim do you think would be made that would not be covered by your insurance?
Like, let's say a homeowner says got infected in the common areas, in the swimming pool, for example.
I mean, they sue the association because they think you're somehow responsible.
Well, that was my question. Is there any liability for the board to respond for that kind of claims?
Just there's no real claim to be made doesn't mean people don't bring lawsuits and try to hold deeper pockets, such as in association situations. And one of the purposes of insurance is to provide a defense under those circumstances. While the insurance may not cover the actual claim that might apply to something having to do with the virus because of that type of exclusion, that would still provide for the coverage of a defense with what they call a reservation of rights, where they indicate in an initial letter to you that will provide you a defense, reserving their rights as to other issues. Now, some will flat out refuse to provide coverage because there's an exclusion in the policy for communicable diseases, and under those circumstances, the association would have to bear its own expenses. The association indemnifies the board members whether there's insurance or not. So it's not as if the board members are personally on the hook to have to defend themselves.
Okay. Thank you. Thank you so much.
Thanks, Maria. We have an open line at 888-565-1470. Robert, give everybody your phone number and your website address before we go to break.
Our phone number is 1-800-974-0680. You can reach us at info@kbrlegal.com or go to the website at kbrlegal.com.
And you are open.
We are open, yes. We are.
We're going to go to we're going to go to break. And like I said, if you've got a question, HOA, condo question for Robert, give us a call here at 888-565-1470. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
And we are back. This is the Ask the Expert show. I'm host Steve O. I'm here with Robert from the Kaye Bender Rembaum law firm. They do association, community association law. Before we go to our phones, I have one of our emails that said, Robert, I love your show. I am a board member. Do you think things will change with how we do business with the unit owners having the same opportunity as video streaming? Do you think things will change?
Read that again.
They want to know if, right now they have to come to a meeting, but they can't because of the virus. So a lot of them are doing this like we're doing here, video streaming. And he's wondering if people from out of town will be able to do the streaming, or do they have to be there at the meeting?
I think a lot of our clients have expressed that they are actually very pleased with having the ability to do meetings in a virtual fashion, particularly in situations where the host of the meeting, the chairperson, has control over who can speak and is able to have better order of the meeting as it goes on without being interrupted by outbursts that happen often enough in these types of settings. I think that the statutes will probably have to be tweaked to provide for a little more clarity on the usage of this on a more exclusive basis. I mean, it does authorize meetings of the board to be held that way. Member meetings are a little less clear on that particular issue, so there may need to be some additional legislative action to help that along. Once this condition subsides and things get closer to normalcy, it's hard to predict whether people will be comfortable in getting together in these types of groups for quite some time. So it seems that this might be with us for a while.
Okay. Let's go back to our phones. John. Hi, John.
Yes.
You have a question for Robert?
Yes, I do. Shall I go ahead and say it?
Go right ahead. You're live.
Hi, Robert. In 2017, the Florida representatives passed a law that said you couldn't serve more than 8 consecutive years on the board, and that is not enough. They're not enforcing that. I heard recently that in the 19 session, maybe the 20 session, they agreed that it is going to be in effect, and if you've already served 8 years, you're done for a year. Is that correct?
No. What actually happened in 2017, the amendment to the statute said that individuals could serve more consecutive year terms. And then in 2018, that was amended to go to 8 years maximum because not everybody had 2-year terms, and that didn't make a whole lot of sense. But the important factor that has to be kept in mind is that the legislation begins when it became effective in 2018. So the year rotation began in 2018, and anybody who served before that, that time doesn't count towards the 8-year limit. It all begins on July 1, 2018, and so the election that follows, so it really won't kick in until 2026.
Wow, that's we've got a person on the board right now who's serving 13 consecutive years.
Well, if the people vote him in, or if not enough people run to change it, that will be allowed to continue at least until 2026. Now, there are other exceptions to the limitation, such as if there aren't enough candidates to serve on the board, or if the individual receives more than 2/3 of the vote at the election, then that overcomes the term limit provision in the statute. And by 2026,
that doesn't take effect until 2026. Is that what you just said?
2026 will be 8 years from when the statute became effective, and that's the first time it will apply to anybody's consecutive terms.
Yes. So the fact that she didn't get more the 2/3 required, and there was also more candidates than the 9 that we normally have on the board. So that doesn't make any sense, right?
Well, the first hurdle that has to be crossed is we haven't reached 8 years for her, even though she's been on the board 13 years. Again, the clock didn't start running until July 1, 2018.
Yeah.
So if there was an election after July 1, 2018, that's when it began.
Okay. That seems kind of weird, but that's the way they do things in the government, I guess.
It's a constitutional issue. Both the Florida Constitution and the United States Constitution have a provision that says that a state cannot adopt a law that will impair or affect a substantial contractual right. And they can't do that retroactively. They can do it prospectively, meaning into the future, but they can't go retroactive on that. Unless the statute in its adoption says so specifically, which this one does not.
Correct. Okay, thank you very much for your help.
All right.
Thanks, John.
Thanks for listening.
Before we go to a break, I'm going to have to get caught up. Here's an old familiar question. Hudson in Hollywood. Are there new laws about service animals and emotional support animals? And what about the doctors that lie about the service animals?
Well, the laws that have evolved do not really amount to significant change when it comes to emotional service animals. There are requirements that the requesting resident has to meet in order to qualify. They have to provide documentation from a qualified medical individual. It doesn't have to be a doctor. It could be a mental health counselor, that they have a condition that affects major life functions and that they need this specific animal to alleviate those conditions so that they can fully use and enjoy the property. And it's a pretty low bar for them to have to meet. for communities that are addressing this, we recommend having a application process in place where there are forms they fill out and an affidavit that gets submitted to the medical provider to submit that has the necessary information, and that the owners be required to provide that to the association, as well as there be rules in place for the community once they have emotional support animals on site as to how these animals are to be handled in a fashion that doesn't violate the requirements of the discrimination law, but still allows the rest of the community the peaceful enjoyment of the property without a nuisance. The emotional support animal still is not allowed to be a nuisance to the community as a whole. So there are issues that can be addressed in that respect as well.
Okay, we're going to give everybody your phone number, Robert, and your website address. We're going to go to our next break.
All right, you can reach us at 800-974-0680. That'll get you through to Pompano Beach or Palm Beach Gardens or Tampa. And you can reach us on our website at kbrlegal.com or email info@kbrlegal.com.
And we have an open line at 888-565-1470. If you have a question for Robert, and we have a ton of emails that have come in this week. We're going to go to break. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680. You are listening to the Ask the Expert Show with host Steve-O. We will be right back with more experts in the field of legal, health, financial, and home improvement. Join us every Thursday from 5 to 6 p.m. Now, get ready for more Ask the Experts.
And we are back. We're here with the Kaye Bender Rembaum Show. I call it that because it is our most popular show of all the shows we do. It's on the first Thursday of the month from 6 to 7. And I got to tell you, Robert, we had a lot of people asking that question about liability with the virus. You know, someone just called and asked about that. We had presidents of associations contact us wanting to know, what are you telling your people about gloves and masks, and are you telling them what they should be aware of?
Well, the determination of what steps are required within the community is going to depend on the community and the layout. So it's more of a case-by-case basis as to what's necessary. Gloves is really something that is not helpful to anybody in the long run. Gloves don't really protect an individual from getting it, and you can't spread it through your hands. So the point of gloves is maybe you don't touch your face, but people tend to do that anyway, whether they're wearing gloves or not. And gloves can actually make situations worse, I've been told by some medical professionals. So the masks are an issue, and some communities can require masks in the areas if it's appropriate for the layout and is necessary. there's not, because they don't have situations where people might come into closer contact with each other. It's really more about the social distancing and the possible self-quarantining of individuals who may have had exposure or become infected on their own. And those are the situations that get to be most hairy. How to address that? The association can't make an announcement, hey, the owner of Unit 214 has tested positive for the virus. They can't do that. They can, some building has, but can't say who.
Okay. Before we go to our next call, I want to get this one in. It says 25% haven't been paying their assessments. Why should I be penalized by the management company? How do we prepare for the onslaught of foreclosures that might be coming up? Should we apply for a line of credit?
Well, that's certainly a very important concern, because the association has ongoing obligations and expenses in operating the community, and they need their assessments to be paid in a timely fashion by individuals that own the units. And if any individual has a problem, they need to contact the association proactively and work something out, as opposed to simply just not paying it, because that could subject them to the possibility of a lien and foreclosure on their property. Mortgages that are federally backed are not going to be foreclosing in the immediate future. Community associations and investments are, and they are not subject to those same limitations that the federal government put in place for those particular mortgages. And it's very important that people recognize that the assessments are among their most important obligations to be paying. If they're going to cut anything out, it's like not paying FPL. Don't not pay your assessments without getting in touch with the board proactively and work something out, so that you're not facing significant additional expenses that could come with being put into the collection process.
Okay. Let's go to Bernice. Hi, Bernice.
Hi.
Hello, Bernice.
Do you have a question
I'm
for Robert?
calling concerning the complex I'm living in. Yeah. Name of it is Water's Edge of Tamarack.
Water's Edge of Tamarack. Okay.
Let me turn my radio off, so.
Please.
Okay. And the Phoenix Management Services is responsible for this complex.
Okay.
It's situated in Northwest 93rd Terrace in Tamarack. Now, when they did over the driveway in 2017, they did not did the driveway properly when it was finished. When the water comes off of the building, it uses to go directly to the street. Now the water comes to my garage door. And I wrote letters 2017, 18, and 19 with no response from the office.
Okay. Well,
And
first off,
I'm just calling to find out what can I do about it.
okay. Well, the property management company isn't responsible for your community. The board of directors association is, and the management company works with them and does what the board instructs them to do or not do. If you're writing to the management company, that may not be reaching the board because you're writing to the management company and they may not be responsive. But does your board hold board meetings?
Well, I gave the last letter directly to the board of director. Her name is Kelly. I gave her the letter in her hand, and I still haven't heard a word.
Okay, well, what you probably have to do, because it sounds like the board is not doing what they need to do for your problem, is you probably need to find an attorney to represent you to let the board know that this is a serious issue that they're going to have to address and not just ignore.
Okay. So that's the only way I can get
Well, it's not the only way. It's the only way because the board is ignoring you. That's one way that might get their attention a little faster. If you can communicate directly with the board member and get answers, even if it's over the telephone, to what the situation is and what, if anything, they plan to do about it to resolve this problem. But as time goes on, your rights become weaker. So you want to take care of that no later than 4 years after the time that the problem began.
Okay, it's over 3 years now.
Right. So that's why getting an attorney involved now is more important.
Okay, thank you.
Good luck,
Thank you,
Bernice.
Bernice.
Bye-bye.
So we've got here. This is really a strange question. Maybe not to you. This is Mike from Boca. He said they have rental security deposits in their coffers that renters never claimed. Who does that money belong to? There was no claim by a tenant. Is there a statute of limitations?
Did he say whether it's a condominium or a homeowner
It does
association?
not say.
Okay. Well, generally speaking, the security deposits that you take from tenants in the community association setting are there to protect damages to the common areas, common elements by the tenants. So if the tenants don't look for it, then you would get in touch with the unit owner who's renting the property and see about providing it. It would be most likely for them more than the association. But if nobody claims it after 5 years, then the association pretty much write it off the books.
Okay. Here's one from Lewis and Davy. He says, I never miss one of your shows. A resident, you don't either, do you? A resident is married to someone on our condo board, and the condo is in her name. Can the husband run for the board?
Well, that will depend on their governing document, particularly the articles of incorporation for the association will have to be reviewed to see if there's a limitation as to whether or not ownership is a requirement to run for the board. Some documents will require only owners can run. Some will say owners and their spouse. And some don't say anything at all, which means anybody can run whether they own there or not. So that's a document that needs to be reviewed to get the answer to that question.
Okay. Boy, this is a good question for you because you would never do this. Can a law firm lock you into a long-term contract?
A law firm?
Yes.
For what?
I don't know. I guess apparently they must have a law firm.
If it's a long-term contract to use the lawyer, the answer is no.
Okay.
Clients can go to whoever they want, whenever they want. They are not bound to long-term. Now, the lawyer may have a claim against the association or whoever's contracting with them for fees that may have accrued. They may have what's referred to as a retention lien on property or lien against the claim itself. And it depends on what the issue is and what the lawyer's doing as to whether, but who's going to represent you under the circumstances is something you can change at any time.
We got a lot of questions from people wanting to know if they're that are requesting records, um, and they're not getting them, and they're being told that because the pandemic is slowing things down. Is that true? I mean, we still
Well,
have email.
the problem we have with record inspection is the way the statutes are written is that unit owners, homeowners, members of associations have a right to make a written request to inspect the official records of the association physically and either copy it with their own device or request copies be made of items that they identify. But the statute does not provide that the owner can say, "Hey, I want these records. Go find them for me and send them to me either by mail or email or whatever I decide is best for me." That's not an option. So the problem is, since we are having to do our social distancing and there are limitations on getting together in certain situations, some associations are not able to accommodate record inspections under these circumstances, and they're being delayed. Whether or not the association is going to be found to be in violation is a question nobody really knows the answer to because it's never happened before under these types of circumstances. And opinion is they would not because of the situation that we face and that the record uh, are not that critical to somebody's life that we should risk exposure to potentially life-threatening disease to provide somebody with the opportunity to look at them.
I think you answered this one at the beginning of the show. This is from Pat in Jupiter. Does the emergency powers apply to the virus?
Well, I think that given the announcement that was made by the Division of Condominiums last month, uh, their opinion is that it applies even to circumstances they don't have jurisdiction over, uh, into the homeowner association as well. Ultimately, it's going to be a court that will make that decision, but I think that most people in the state have been acting as if it does apply, and I think
It's
that
normally for hurricanes, right?
that's the way it was originally written. And so it's written in a way that doesn't exactly fit the circumstances that we're facing, but you can jam it into the round peg into the square hole a little bit under the present circumstances without too much fear of having some kind of a court determination against you for that violation.
Okay. Hey, let's go to Paul. Hi, Paul.
Hi, how are you?
Good.
Good. I'm on a board of directors for a small homeowners association that you guys actually are our legal counsel for. We are 50 homeowners with no management team. It's just volunteers on the board. I have just a question for the Architectural Review Committee, and are we responsible for asking for permitting of certain things like fences, roofs, whatever the association member is doing? And if so, should we be put on the insurance policy from the tradesmen?
Okay. In your homeowner association, do you have common property the association oversees, or what is it that your HOA does other than review potential changes to the exterior?
Well, I mean, I guess I don't understand your question. What do we do?
Well,
It's a full.
from the perspective of insurance, what property do you have that might be damaged by a contractor?
Well, we have roads. We have some common properties that are at the end of roads. We have circles that some of the larger trucks do, cut across sometimes when they're making deliveries or coming in and out of the property. We have a front gate that can be damaged depending on the size of the truck. And I don't know whether we would be responsible for any other properties, but I guess my question is, does it make sense to be added to the tradesman's insurance policy?
Well, you do have an interest that you'd want to see protected. What exactly you can or cannot ask for is going to depend on the language within your declaration of covenants as it applies to architectural changes, and whether or not the board has the ability to require additional items, whether or not you should be having specifications in place in an objective format that you could hand to somebody. Here's what the requirements are for any changes, and you have to meet these, submit the application and meet these specifications. And whether or not it makes sense to require as an additional condition for approval that there be insurance in place that names the association as additional insured. These are all things that your documents have to be reviewed in order to tell you whether or not you can actually do that, or whether you may need to make revisions to them to give you that authority if that's something you want.
Okay. Well, our CNRs did not have anything that requires insurance from a contractor that's doing work on a homeowner's. Okay.
It may not be as specific as that, but it may still provide you with sufficient authority in how you set up your specifications and requirements and the approval process. So if you say where you're
can that be added as a bylaw, not a bylaw, but a rule and regulation, or would it have to be in the CNRs?
It's very possible it could be in the rules, but again, the documents have to be reviewed to tell you whether or not that's the case.
Okay. So and then the other part of my question was about permitting.
That's the same category as whether it extends to the point of needing to require a permit. I mean, quite often the city or county is on top of that without you having to be involved as well. Sometimes the requirement of the association with permitting can add a level of liability to the association that some boards may not want to take on. So those are things to keep in mind when you're deciding which way to go on that.
Okay. I appreciate your help.
Right, Paul. Get with your attorney.
Thank you.
Hey, Steve, but we go on much further. I just want to go over what talked about earlier with the upcoming webinars.
Sure.
On May 11th, there's two separate webinars covering emergency orders in Broward and Palm Beach County. The one for Broward is at 11:30 to 12:15, and the Palm Beach one is at 12:30 to 1:15. Michael Bender and Jeff Rembaum will be part of the panel with members of Campbell Property Management. All of this is going to be found on our website at kbrlegal.com /seminars. On May the 12th, there's a 1-hour legal update 2020 from 1 o'clock to 2 o'clock. Lisa McGill, an attorney in our office, will be the presenter on the CAI Southeast Florida webinar. May the 14th, COVID-19 in your association from 2 o'clock to 3:30. Lisa McGill will be among panelists. The webinar is via hoaleader.com, and you have to join to view the webinar. Joining is free during COVID-19. hoaleader.com. May the 14th. May the 19th, CAI Florida Legislative Alliance webinar on review of 2020 approved community association legislation at 12 noon. Michael Bender will be involved. That's on our website calendar at kbrlegal.com. Registration information has not yet been announced, but check that on our website for May the 19th. May the 20th, board member certification, 9 o'clock to 11:30. Lisa McGill, co-hosted with Campbell Property Manager. And May 27th, condominium board member certification, 1 to 3 o'clock. Andrew Black is the presenter. KBRlegal.com will have this information.
Got it all in. We got it all in. Hey, stay
Thank
well.
you.
We need you next month.
Yes, sir. You too.
Okay. Thanks so much. And we'll be back on Monday from 6 to 7 with more Ask the Experts. Thank you, Robert.
Thank you, Steve. Be well.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of the station, its staff, management, or sponsors.